Hi, everyone. Welcome to today's webinar. My name is Stacy Satang with the Housing Alliance of Pennsylvania. Thank you for joining us. Our webinar today is titled Housing Law Part 1 of a two-part series. To let you know, this presentation is being recorded and will run approximately 90 minutes, including question and answer time. Additionally, please note that anything in the chat feature does automatically get saved. We will send you a link to this recording via email after part 2. So you'll get one email with both recordings at the end of next week, as well as we will upload both recordings to our YouTube page and post it on our website. Attendees, you'll all be muted during today's presentation. If you have a question for the presenters, please type that into the Q&A box at the bottom of your screen. If you have a logistical question for myself or other Housing Alliance staff, please use the chat feature. The chat feature should not be used for questions for the presenters. Please only use the Q&A for that. I'll now turn it over to Gail Schwartz to begin today's presentation.
Hello, everyone, and thank you for joining today's presentation on Housing Law 101. I'm super excited for this presentation. I think, housing law is a common denominator amongst the Housing Alliance membership, whether you are the owner and operator of housing or you are the advocate who is walking alongside a tenant in search of housing, or you yourself are potentially a tenant. So we know we have a very diverse group joining us today, and we are going to have a well-rounded conversation around the different laws that are in play that can come into contact when you are dealing with landlord-tenant housing opportunities. Again, today is very much an educational webinar. If you are somebody who is actively in a landlord-tenant conflict and you are in need of legal guidance or legal advice, we strongly recommend that you contact legal services in your community. Again, this is an education webinar, a high-level overview, and nothing presented today should be considered legal advice on a specific situation. So with that, I do want to introduce our amazing speaker. We have Kadeem Morris from Community Legal Services. He has been working on the landlord-tenant front for a while now and has put together some presentations for us in the past, and I'm really excited for today's presentation. So with that, I am going to pass it over to you.
Thanks, Gail. I'm excited and slightly intimidated by the fact that there are 326 participants on today's webinar. So hopefully all 326 of you will leave with some additional knowledge at the end of today's presentation. That's always my goal. I know the chat feature is not to be used kind of just generally, but I would like if we could take a second just to identify the types of people who are in the room. I know we have some probably tenants, attorneys, advocates. So if you could just pop that in really quickly, just so that I can see what the audience is like, just for my own purposes as I kind of guide this. So lots of housing counselors, service coordinators, great. So kind of the intended audience for this presentation. So I'm gonna go ahead and share my screen. We have some landlords also, that is great. I like to have varied perspectives, so that's good. Can everyone see the screen that I'm sharing? Okay, wonderful. So this is Housing Law 101. It's part 1 of a two-part series. As was mentioned, we're gonna, in the first part of the series, walk you through some basic housing law principles and give you the information that we need. I am Kadeem Morris. I'm a staff attorney here at CLS in the housing unit. So the goals for the training are as follows: provide participants with an understanding of housing law, the basic principles that are applicable, explain the differences between general housing law in the landlord-tenant renter context and mobile home park laws, which are slightly different, but are still applicable as you go around the state, where housing is very varied in Pennsylvania. It's not just brick and mortar homes. And also part 2 of our training will explore emergent trends in housing law, which is going to be next week. And then we'll talk about fair housing, DV protections, reasonable accommodations, and kind of everything that you build on once we started off with a good housing law foundation. So thank you to the people who put your various positions in the chat. We have mediators also, so that's really great. We're going to try and hopefully give everyone something to walk away with today. So this slide is really, it'll be included. I tried to cover most of the legal services agencies, the people who you should really contact for referrals and advice on specific case-related issues. This is just an educational presentation, as Gail said. So we're going to have a Q&A section. There'll be some polls throughout just to make sure everyone stays engaged and we're on the same page with our concepts. But if you have any questions, use the Q&A feature. And I see that the Q&A feature, oh, those are just the anonymous postings of what people's positions are. You will get the slides. I believe it'll be sent as one at the end of next week's presentation. You get one large packet. So the slides will be made available to everyone. Okay, so landlord-tenant basics. We're just going to start off with a basic understanding of housing law in terms of how a landlord-tenant relationship is formed. It takes two people, generally, or two parties, essentially, a landlord and a tenant. And the question is there a landlord-tenant relationship? That can be either done through a lease agreement, which I'm sure a lot of people are familiar with themselves, either haven't seen a lease or signed a lease for their own housing, or helped someone as a result of them bringing in a lease and having a question or an issue around it. The other question is someone paying rent? That's important because if you live with someone and you're not paying rent and it's an oral agreement that you can stay there, that may not necessarily be a landlord-tenant relationship. There has to be a transfer of benefits on both sides. Essentially, I'm giving you housing in exchange for something else. And do they have exclusive possession of a particular space? If you are in a studio and there are just two people in a studio and there's no place that's exclusively yours that you can use and really call your domain, that may not necessarily be construed as a landlord-tenant relationship. But if you're in a 2-bedroom house and I have my own room in your house, even though we might share like some common spaces like a bathroom or a kitchen, that can be construed as a landlord-tenant relationship. The big thing to note when you're dealing with clients or as a service provider is that if there is a legal action in an eviction court or an attempt at mediation between the parties, that's usually an acknowledgement by the landlord or someone else that there is this relationship that exists between the parties. So once you get to the stage where someone is like, I have been taken to court by this person, you likely have a landlord-tenant relationship. There's the odd instance where you might be dealing with an ejectment action, which is not a landlord-tenant action. It's not something that we'll focus on, but it's a different type of court proceeding where there's an acknowledgement that there is no landlord-tenant relationship. So there is no set definition for what a tenant is, but we kind of define it based on day-to-day experiences. Someone who has exclusive possession of a home or apartment for a fee by agreement. The fee has to be specifically for that housing, and it has to be by agreement of the parties. So is there a lease? That's really the first question in the is there a landlord-tenant relationship? In Pennsylvania, you can have written or oral leases. The written leases are most common. If you work with apartment associations or if you are a landlord, there are form leases that are available to you online. If you do this work pretty often, you'll see the same type of lease pop up, even though the parties might be different, and they have very specific terms and they set the obligations for each party. In Pennsylvania, your leases can also be oral, just by agreement. The way you kind of prove or substantiate an oral lease is that you are making these payments, either checks, money order, cash payments to this person, and this person is accepting these payments and allowing you to have exclusive possession of some part of a property for some duration of time. Leases can be month to month, they can be yearly, they can be 2 years or longer. If a lease is 2 years or longer, by law, it must be in writing. You also have what are called rent-to-own relationships, where someone thinks that they are buying a property prospectively, but they're paying rent for a certain time period. And only when they get to the end of the time period do they own the property. That is technically a lease, but it's technically also a housing purchase contract. It's a bit complicated. We're not going to focus on it, but it's something that you might see. And there's also a different variation called an installment sales contract, which operates in the same way, but these are all up until the point that all of the required payments are made. These are all technically leases under Pennsylvania law. So what type of housing is out there? I think most people are familiar with private market rate housing. It's where I, as a tenant by myself, go out into the open market and look for a home that's available for rent. And I find a landlord and we come to an agreement and I have a private market rental property. There's also federally subsidized housing, which can be public housing, which is your general housing authority, the buildings that they own. There's Section 8, which is a voucher program where the housing authority assists someone in living in a private market rate housing property while the housing authority pays a portion of their rent. There's project-based housing, which is kind of like your traditional housing authority property, except it might be exclusive to former victims of domestic violence as transitional housing. It might be for seniors. Those are different types of housings that are based on particular categories. And there are also LIHTC properties, which are for low to middle income homeowners, and they are federally subsidized, but in a different way. Like the landlord gets certain incentives from the city or state at the time that the property is being constructed to keep a certain number of units at an affordable rate. And those units are available through a complicated system of processes that you get to, and you can have a LIHTC unit. And there's also, of course, mobile home parks or mobile home communities. Now, those are not your typical market rate housing. It's essentially a community where people live in movable but not often moved homes, that the land is not owned by the homeowner, and there are different community rules that govern. So think of it as a gated community on wheels that really never moves, essentially. So this is our first hypo, and it really gets to the question, and I think it's going to be launched as a poll. It really gets to the question that we were just talking about of, is there a landlord-tenant relationship? So we've got Mary and her children. They are living in Paul's home with Paul and his mother. And every month, Mary gives Paul $100 for her share of the groceries. Additionally, the cable bill is in Mary's son's name. Is there a landlord-tenant relationship? Yes or no? I'm going to give people about a minute to kind of answer the question, and then we can kind of gauge where we are in the conversation. So please vote. I expect to see 365 votes, or at least 300 votes, and we will talk about it as soon as there is an answer to the poll. I think will be up for about a minute so that people can work through it.
While people are answering that poll, I'm wondering if you could just answer a question real quick.
Sure.
What does default provisions apply mean under an oral lease?
Okay, so that's kind of a complicated sentence. Default provisions are, there are some basic requirements that Pennsylvania law sets out for a lease to exist between the parties. It can be that you have to give a certain amount of notice. Usually it might be around 30 days. It might say that if your lease provision, your late fees can only be a certain percentage of your rent. Usually it's around 10%. So default provisions are the provisions that are set out in Pennsylvania law. In Pennsylvania, a lot of things are waivable or can be changed essentially in a lease, which happens, I think, depending on the landlord and the parties. They can negotiate a lot of things, but default provision is whatever the basic of the law says, then that will apply. You can go ahead and display the poll results so we can see where we are. Okay, so I've got almost a 50-50 split. This is rather interesting, and I'm gonna walk through my understanding of the question. So, is there a landlord-tenant relationship? That requires a lease between the parties, or it can be an oral agreement. Here there is some agreement that Mary and her kids can live with Paul and his mother. There's no exclusive possession of a property, and technically there is no fee, because Mary is contributing to groceries, but she's not contributing to rent. So this type of case, typically where there is no unless there's something else. I think the cable bill being in Mary's son's name, that's just an additional piece of information that's just thrown in there to kind of throw a wrench in the conversation, but we're really focusing on, is there a lease or law written? Is there exclusive possession of some part of the property? Like if this was written differently that says Mary and her children rent or share a room in Paul and his mom's house, and Mary pays, let's say, $100 towards groceries, and additional $200 a month in exchange for the ability to live there, that would be more construed as a landlord-tenant relationship. If they have, so I would say, to Brittany's question at this point, I would not construe facts that are not in the hypo. If they do have exclusive possession, or and there's an oral lease or agreement between the parties that it is exclusive and they can stay there, then you can use that as a basis to kind of say that there is a lease. But the goal of the exercise is to kind of look at those three main factors. Is there a lease? There's no lease, neither oral or written, at least the way I constructed the hypo. There is no exclusive possession, and there is no fee that is being paid in exchange for them staying there. It says that Mary contributes to the groceries, which is something that happens in like a lot of family type settings where you don't have a formal landlord-tenant relationship, but a friend or family member is staying with you for a short time period, and they might say, okay, while I'm here, here's some money towards groceries because I'm eating your food. It's not a formalized landlord-tenant relationship where they have exclusive possession of a part of your home. The cable bill being in her son's name, if the son is there and he wants cable, they might allow him to do that, but I don't think you should construe those facts without additional information as a landlord-tenant relationship. But it is a difficult question, and some people might interpret it differently, so I'm glad that there is some disagreement, and we can talk about that more as we have time, maybe in the Q&A section. So let's talk about the eviction process and what should actually happen. So generally speaking, and this is where I was talking Brittany, thank you for your feedback on the hypo. If it comes up again, I will make it more clear. So in terms of the eviction process, here are the steps that should happen. And there was a question earlier about default provisions, and these are essentially the default steps that should happen in an eviction process. There should be notice. A landlord who's seeking to evict a tenant should serve the tenant with notice of the eviction proceedings, either by a letter that says you have 10 days, 15 days, 30 days to vacate the property, after which they should then file a complaint in court. And then once the complaint is filed and served on the tenant, then there should be a hearing that's scheduled where a decision is made in court. And if the decision is negative or positive for the tenant or the landlord, either party can appeal that decision and go to a higher court. So you start at usually like the MDJ or municipal court level, where you have your first hearing, and whoever loses at that level has a de novo right to appeal to the Court of Common Pleas, which is usually your county, in the county seat, like the large courthouses in most of the counties. And then you can go there with your appeal. And then if you don't appeal, then the eviction process usually starts with an order of possession that is issued by the court 10 days after the initial hearing. And then 11 days after that, you can usually have a lockout if there's a judgment by the tenant. Now, what's important to know at this juncture is that if you do not follow this process, it's an illegal lockout. So if you don't have a hearing before a judge, and the judge doesn't make a decision as to whether or not you get to maintain possession of the home that you are living in, then that's what's called an illegal eviction. So let's talk about notice as a default, or just if there's no write-in that does something differently. The Landlord-Tenant Act requires the landlord to provide written notice to a tenant that specifies the grounds for eviction. And unfortunately, but fortunately in Pennsylvania, these the provisions of notice can be waived or altered. So usually if a lease is a year or more, you're required to give 30 days notice. If a lease is less than a year, let's say 6 months or a month to month, you're required to give 15 days notice for end of lease term. If it's non-payment of rent, you give 10 days notice. If it's breach of a lease, you give 15 days notice. So I'm going to ask people to use the Q&A function and not the chat box to communicate questions, because the chat box is not being monitored in that way. So if there's a question specifically, then you should actually use the Q&A. But in terms of a non-renewal, which is also known as an end of lease term, if your lease does not specify something different, then you should give the default 30 or 15 days notice, depending on whether or not it's a 6-month lease or a lease for a year or more. And this is assuming that you have to initiate an eviction and the person does not move out of the property. Now, it's important to note that if you have a written lease, then you can waive the notice provisions, which means you can essentially file the complaint, and the complaint is the person's notice of their eviction. But if the lease is oral, then you cannot actually do that. You actually have to serve the person with notice and then file the complaint. So this is just an emergent issue that I wanted to flag, and you'll get this information in your packet when you get it next week. The Cdc Eviction Moratorium does exist. We'll speak about that a little more next week. But what it requires is that if a landlord, a landlord's agent, or someone acting on the behalf of the landlord is attempting to collect a debt, so usually in a non-payment of rent circumstance where the tenant owes some money, or the landlord alleges that the tenant owes some money, you're required to give the tenant notice of the Cdc moratorium and the availability of rental assistance and other resources that may be available to help the tenant in this time period as it relates to the pandemic. Now, it's kind of hard to parse out who is an agent, who's actually a debt collector, as is defined. Any person or business who's attempting to collect on a debt or money that's owed, who does this as a regular course of business. So in terms of erring on the side of caution for this, we would say that everyone should send the notice regardless of whether or not it's a non-payment of rent case. Because if you get to court and then you're alleging as an additional fact or issue that the tenant owes you rent, then you have violated this requirement or this internal rule based on the Fair Debt Collection Practices Act. So send the notice that these issues or resources are available to them at the time that you were serving notice in your complaint. If notice is waived, then it must also be sent at the time that the eviction complaint is being served, and you must notify tenants of their rights under the Cdc moratorium. And you can't construe that based on your tenant's income or information that you might have had at the time of application, that this does not apply to them. It's an err on the side of caution thing where everyone should get this information and you don't make a decision or determination for yourself that the tenant does not qualify because incomes may have changed. Someone may be recently unemployed, so the household composition may be different. So err on the side of caution and send in that notice. And if you actually go to the Fair Debt Collection Practices website for the US government, you can actually get a sample of the information that you are required to provide. So this is another quick poll, and it says, are you acting as a debt collector if you file an eviction, or if you file an eviction, or if you act as an agent of the landlord in an eviction process, hearing, or mediation? And we can launch that poll really quickly. And this,
Great. And do you want to field a couple of questions while people
Sure.
are answering the poll?
Sure.
So one question is, how is an eviction notice served to the tenant?
So usually if you are trying to evict a tenant and you were just given notice, then you should hand deliver, you can hand deliver a letter, you can send it via regular mail. I would suggest at this point, because of the way the Postal Service is operating, is that you send it certified and maybe request a signature so that you can prove that notice was actually given to the tenant. Because if your tenant comes into court with an attorney and they're alleging that notice was not provided and it's required by the lease, or we're doing the default provisions, which is an oral lease, and you're required to give notice anyway, you have to prove to a judge that you gave notice to the tenant at the time that before you filed the case.
Great. And can you give 10-day notice orally? Is that considered a formal notice?
So you can give notice orally if your lease requires no notice, but if you've got no lease or an oral lease agreement, then the best thing to do, or to be able to prove your case in court, you should have some type of writing that specifies what notice you're given, because notice requires, you can't just say, I'm evicting you in 10 days. You have to say, I'm evicting you in 10 days for these specific reasons, either because you're behind on your rent, your lease is over, or you violated your lease agreement in this specific way. So you can't, in a 10-day oral notice is not really going to be sufficient to communicate those facts. Now you can have a follow-up conversation with your tenant at any point and have that conversation, but in terms of proving that you had it, it's a bit harder to do when you just have a phone call where things get misconstrued.
Excellent, excellent. So I think our poll is done.
Okay. So most people have selected no, and I'm going to tell you why no really works in this instance. So in this instance, under the Fair Debt Collection Act, it's only if you are trying to collect money or a debt from someone. So if it's a breach, or if the lease is over and you would just seek in possession on that basis, meaning you're trying to have the tenant removed from the property because you don't want to renew the lease, then you're not acting as a debt collector. The moment you go into court and you request that the court actually gives you financial relief, or you say this tenant might be behind $100 or they failed to pay the late fee or something like that, that is collection of a debt. A debt is something that is owed to someone else, and possession is not really considered a debt. Now, technically speaking, erring on the side of caution, everyone should still send the notice if you're operating in that space, because it gets a bit hard to parse out individual cases if you have large volumes. But unless you're trying to collect on a debt from someone, then you're not considered a debt collector by virtue of you just being present or filing an eviction complaint. Hopefully that was clear to most people. Okay, so grounds for eviction. This is kind of what we were talking about in the last typo. There are 3 grounds for an eviction. There's non-payment of rent, which is where you are trying to collect a debt that is owed to the landlord from someone else. There's termination of term, whether it's a year, 6 months, 2 years, or longer. Your lease has officially ended and you are seeking possession to be returned to the property owner on that basis, or breach of a condition of a lease. A breach of a condition could be you are violating the occupancy requirements, like if the lease says this property is rented to a mom and her son, and she moves 2 other people in, that could be a violation of the lease agreement. Having unauthorized pets could be a violation of the lease agreement. There's like altering the condition of the property, like breaking down a wall or painting a wall without asking the landlord's permission. All of those things are construed as breaches of a lease agreement and are separate grounds for an eviction. So eviction defenses, or things that will come up as you go to court, these are issues that will be raised by tenants or landlords should be aware of as they navigate this process. There's the implied warranty of habitability, or you can call it fitness for a particular purpose, that says if you're renting a house, the house has to be livable. Now, there is no gold standard of livable. It just has to not, let's say, have a hole in the wall, be infested with rodents. The stove, if you provide a stove, a fridge, a microwave, all of those things should be in working condition when rented to an individual, and they should be maintained throughout the duration of the tenancy. So that's kind of called a warranty of habitability. You should have heat in the winter, or like air conditioning in the summer, if that is like a centralized unit that's provided. Those are the things that you really think about when you're looking at the implied warranty of habitability. Protection for subsidized tenants. There are some additional steps that, depending on the nature of your property, they might have a right to an internal appeal with the housing authority if you're, let's say, removing them for breach or something else. So those are separate provisions that could also apply. Is the tenant withholding rent? A tenant can withhold rent because you have failed to make a repair or failed to maintain the property in a habitable condition. And that's a valid defense if the tenant can prove that they have followed the required steps. And is this a repair and deduct case? Has withholding rent failed essentially, and has the tenant gone ahead and repaired the issue? Let's say someone doesn't have heat in the winter because the heater is broken, and they told you this in November, and it's now January and the heater is still broken. They can repair and deduct and document and reduct a reasonable cost of that repair from your rent. And protections for victims of domestic violence. There are certain instances where a victim of domestic violence can be or should be allowed to break their lease term or have another party removed from their lease if there's domestic violence incident that's happening at the property. So those are things that you should be aware of. And you shouldn't evict someone because they're the victim of domestic violence, because there are all protections that come into play and effect when you are dealing with those types of cases. And VAWA is the Violence Against Women's Act. So the implied warranty of habitability, very simply, a tenant's obligation to pay rent is conditioned on a landlord providing a habitable home. As I said, there's no set standard as to what a habitable home is. It varies from location to location. Like, all of our homes are different, but everything should be in working order. And if there's something that's provided or required under the lease, then it should be provided in a working condition. Like, not having hardwood floors is not a violation of the implied warranty of habitability, but having a hole in the floor as you walk in or anywhere in the property is considered a violation of the implied warranty of habitability. This cannot be waived, although some leases do try to waive it and shift the burden of repairs onto tenants. This is an unenforceable attempt at burden shifting. So just to be aware for everyone, if a lease says you are responsible for the financial cost of all repairs, that's not an enforceable provision by itself. Now, if the landlord can prove that there was negligence or some sort of malicious act by the tenant that created this condition, but if because of poor maintenance, let's say the ceiling falls in or there's a leak in the roof and you notify the landlord and the landlord does not take action to remedy that, and you have to live with a leak for a month or 2 months, that's considered a violation of the implied warranty of habitability, and that burden is shifted to the tenant unless the tenant, let's say, broke the faucet or something that caused the leak and failed to report it to the landlord so that it could be remedied in a reasonable period of time. So repairs and withholding. This is where it gets really complicated and really tricky for a lot of tenants as they navigate the system, because a lot of people like to have a phone call and say, "Hi, landlord, my heater's not working." Now, in the court system, when you are doing repairs and withholding, or you're withholding rent because of a repair, you have to give notice to the landlord, and it usually must be in writing so that you can prove the date and time that you communicated the issue. Text messages and emails are sufficient to meet the writing requirement, but you also have to give the landlord an opportunity to repair the issue. So you give notice on day one, usually depending on the repair. If it's an emergency repair, you can say like a week to 2 weeks. If it's a non-emergent repair, then it's about 30 days. Like if you've just got, let's say, sheetrock fell off of one wall and it's not emergent, then you can say, okay, the landlord has 30 days to remedy that. In the COVID pandemic period that we are recovering from at this point, courts might be a little more reasonable with the time frame that is given to a landlord to repair non-emergent repairs, just because of weighing the health and safety precautions against the need for a landlord to show up the very next day with 6 people in your home, and that cannot always be accommodated. So that's just something to be aware of. So you have to give notice and writing. A reasonable time has to pass before you try to then withhold rent. So I would say if you are in January and an issue pops up in January, you cannot withhold rent reasonably before February, and you have to give the landlord, I would say generally a golden rule is 30 days to repair the issue. So it would be January, the middle of January, nothing has happened. If in February nothing happens, then you can communicate at that point your intent to withhold rent on a forward going basis, but you can't not pay January's rent for a repair that has happened in January, or not pay February's rent if your system breaks in the last week of January and it has not been repaired automatically. So issues such as lack of heat are considered an emergency. So that's something that your landlord should reasonably remedy within a week or two as they are able, unless they are letting you know that, hey, I have to order a part, or I need an entire new heater, and because of maybe the age of the home and the nature of the heating system, it won't be here for a week or 2 weeks. And then if you have to live elsewhere, that should reasonably be something that you can deduct from rent because you're not able to live and use your property in that time period. So a tenant has the right to withhold rent. Withholding must be reasonable and related to the repair. You can't just say, I'm not paying you any money because of the issue. If it's something that renders your entire home uninhabitable, then you can reasonably withhold rent from the entire home for, I would say, depending on the period. Like if you're out of your house for a week, then you can withhold, let's say, a quarter of your rent. If you're out of your house for 1 day, then that becomes a different conversation as to how much is actually entitled as a withholding, and as to whether or not you would want to withhold in that circumstance. Withholding can prompt retaliatory eviction filings by the landlord. This is not uncommon. Sometimes landlords may choose not to make a repair, or might determine that the cost of the repair exceeds the value of the tenant in the property, and may file an eviction case. Or the tenant, if the tenant doesn't have proof that they notified the landlord of the issue and they withhold rent, they might have had a phone conversation, but they didn't put it in writing, and they go ahead and withhold rent. The landlord might file a case saying that you're late on your rent without, I would say, without a recollection of having had the conversation with you that a month earlier that your heating system was broken. And that's a reasonable grounds for withholding rent. So that's something to be aware of. I would say, to the extent that the parties can negotiate amongst each other a repair plan or a timeline for things to get done, that is often a better way to approach it than just deducting rent for a repair. And of course, tenants can repair and deduct after the landlord is notified and a reasonable time has passed and the repair has failed to be remedied. So post-eviction procedures. So this happens if you've gone through the court process and you have evicted a tenant successfully, or sometimes the security deposit issue happens if your tenant has moved out without going through the court process and the lease is just over. These are things that you should be aware of. So the first thing that needs to happen is that security deposits are generally done according to Pennsylvania law, and there's a separate statute. It's not covered in the Landlord-Tenant Act that requires the landlord within 30 days after a tenant has moved out and surrendered possession of the property. Now, surrendering possession of the property is a really tricky issue because a lot of tenants move out but don't return keys. When you return the keys to your landlord, it's seen as you haven't given up exclusive possession or your rights to the property. If you have keys, you can theoretically come and go for as long as you want, except as you've been removed by the court process, and the court allows a lockout to happen at a certain date. At that point, your keys should no longer work. But if you're voluntarily moving out at a particular date, you have to surrender your keys at that time period. If you're in a property, let's say you agree to move out at the end of March and you are in the property on April 2nd, then you reasonably owe your landlord rent for April because you have exclusive possession of the property at the start of the month. Now, there is a duty to mitigate those damages on the part of the landlord and try to relet the property at some point, but the goal is to move out theoretically at the end of the month so that the next month's rent is not your obligation. So 30 days after you surrender your keys to your landlord, the landlord has to either return your full security deposit to you, minus any deductions that have already been agreed to, or send you an invoice for things for the reasons why your security deposit is not being returned. Things like carpet cleaning and painting are things that often get put on these notices. I would say if you want to charge for carpet cleaning and you're a landlord, you should put it in your lease that says at the end of your tenancy, there will be a fee of X amount of dollars to clean the carpet. Doing something like replacing the carpet in an entire apartment after someone has lived there for 2 to 3 years, that can be construed by a court as reasonable wear and tear, whereas paying, let's say, $100 to have the carpet deep cleaned and vacuumed is something that can reasonably be deducted as a cost of doing business from the tenant's security deposit. But notice should be given of those charges, and they can't just pop up at the end. Also, if someone's lived in your property for 2 to 3 years and you have to come in and repaint, well, that's expected that you have to repaint for the new tenant who's coming in. That's not a charge that you can just apply to the old tenant unless they've materially altered. Let's say you've got a white wall and they've painted it a deep shade of green that you have to do 2 or 3 coats of primer to restore it to the original quality of the property, then that's something that you can charge for. But just having to paint a property after it's been occupied for a period of time is not considered reasonable wear and tear and something that is covered by the landlord. Of course, if you have been evicted or you've been through the municipal or MDJ court process, you have 30 days to appeal a money judgment or 10 days to appeal an order of possession only. And that's done by going to your local county seat and filing the necessary paperwork or connecting with a legal services agency that can hopefully help you to file that. Generally, you have the right to pay and stay if there is a money judgment only or a non-payment of rent eviction and you are being put out of your property because you owe the landlord a certain amount of rent. You have the right to pay that arrearage before the lockout occurs and to be able to stay in the property. You can't do it after, because once you've been locked out, you've given up your right to possession of that property. But if you're still in the property and let's say 3 days later you come into a windfall and you can pay everything that you owe, then you can pay and stay theoretically. So we've got our third hypo, and this is a 2-part hypothetical. It says, after graduation, Jack and his college roommate Michael move into Jack's sister's home. His sister Lucy has moved out of town for work but didn't want to sell her home. Jack and Michael agreed to a 1-year lease with Lucy. Michael moves out in month 10 of the lease, not at the end of it. Is Michael entitled to a return of the portion of his security deposit when he moves out? And does it matter that Michael moved out in month 10 of the 1-year lease? So we're gonna, as we did before, pop up the poll and we will see if there are any Q&A questions that we can answer while people are working on the poll.
Yeah, so first question is, what is the difference when you don't want to renew the lease because the tenant has several lease violations instead of evicting them? Do you still have to give 30-day notice without filing through the court system?
So you're doing a non-lease renewal, which I'm assuming means that you're at the end of the term and you're not renewing the lease. At that point, it's not an eviction, it's just essentially the lease is over. If the tenant stays beyond the, let's say your lease ends at the end of June, you give 30 days notice, meaning that they should be out June 30th. If on July 1st, they're still in possession of the property and you choose to go through the court system and file an eviction at that point, then you're required to, you can either list the breaches and file it as a breach, or you can file it as an end of lease term, termination of term, where the term of the lease has ended and the person is essentially a holdover tenant at that point. But if you're just ending a lease because you're at the end of the lease period and you're given the sufficient notice, whether it's 30 days, 10 days, whatever you've negotiated in your lease agreement, then you don't need to go through the court process to that. And it doesn't really matter whether you're doing it because of breaches or because you just want your property back. You don't have to give a reason at that point. You just say your lease is over, I will not be renewing it.
Great, so it looks like we have leveled off on poll 1.
Okay. So lots of people have concluded that Michael is not entitled to the return of his security deposit. I will tell you that Michael is not entitled to the return of his security deposit at the time at which he moved out. because at that point, the lease is still in effect. But at the end of the lease term, he may be entitled to the return of his security deposit if there is no damage to the property and there are no additional charges that accrue. I think we can do poll 2, and then I can quickly wrap things together in terms of explaining why it may or may not matter that Michael moved out in month 10 of the lease.
Great. And I have another question. If a tenant withholds rent, are they required to put the rent in escrow, or is the documentation of the request for repairs sufficient?
So generally speaking, a tenant is required to place the rent in an escrow account when they are withholding rent. A lot of people do not actually have escrow accounts or don't go into like traditional banking institutions and open those types of accounts. What I usually see, or what usually can happen in court, is the tenant has to prove that they have the funds for the time period that the rent has been withheld. So if you're withholding 3 months rent at $1,000 a month, and you have to show the court that you have $1,000 that's ready and available that you can convey to your landlord if the court does decide that the money is returnable to the landlord. Because the point of withholding rent is that once the repair is made, the money gets handed over to the landlord essentially, or unless the court decides otherwise for whatever reason. And it's not like, if you are alternatively like doing a repair and deduct, then you have to show your invoice that says, I paid $1,000 for this repair after letting it go for 2 months or whatever time period it had been. So if they are withholding rent, they generally have to have escrow or some proof that they have the funds that are ready and available. And it's usually like a bank statement, not like showing your bank account on your phone in court right now because we're in COVID and no one's touching devices. So just some proof of a printout of your account relatively recently that shows the funds are available. So, okay. So it does matter that Michael moved out in month 10 because he is on the hook for months 11 and 12 of the lease. If when he moved out, he paid out months 11 and 12 of the lease, then essentially when the lease is over, he's entitled to whatever portion of the security deposit he paid when Jack moves out. And even if Jack doesn't move out at the point that the lease is over for year 1 and Michael is no longer a party to the lease or the lease is being modified and continued, that security deposit should be returned and split between the parties just for the sake of clarity and not there not being any confusion on a forward-going basis. If Jack is going to stay, the security deposit gets returned. But the important thing to note in this hypo is that tenants or co-tenants or roommates are joint and severally liable for rent. So if Michael didn't pay, Jack is still on the hook. So if Jack is still in the property, the landlord can take Jack or both of them to court. And if Michael doesn't show up, the landlord can proceed against Jack and recoup whatever costs he has incurred or whatever the loss is for him not being there. So it does matter when you move out. If you move out before the end of your lease, you can't demand your security deposit be returned if you are owing for the additional 2 months that are owed, or if you have not paid off that obligation to your landlord. And if the property is still being occupied by one of your co-tenants, then you don't get your security deposit back until the co-tenant moves out, because the properties to secure the security deposit secures the landlord for any damages that take place during the period of the tenancy, which has been agreed as 1 year, not 10 months or 6 months if you move out early. So hopefully that is clear to everyone. So we're going to keep going and we're going to shift focus a little bit to my favorite, like Pennsylvania sort of specific thing that's called mobile home park owners. And I would like to call them homeowners in mobile home parks. It's a little bit complicated. So as most of you may be aware, mobile home parks exist across Pennsylvania. In Pennsylvania, 55% of them have never been moved, meaning that people have lived in the same place in Pennsylvania, whatever community that is, forever. 20% of them have never moved for 10 years or more. So they're just They are, as we would call them, they're movable homes that really don't move. They're trailers, house trailers, static caravans, maybe RVs that have been converted and put up on wheels, but they're prefabricated structures that are built in a factory, and they are almost always placed or located on the land of another person, where the person is collecting what we call lot rent for your ability to use a specific space. It's not a home where you typically think of having like a yard with a front yard or side yard. It's usually you've got your space, someone else relatively close to you might have another space. You might have a little front access or an access to the road, but you don't have like an enclosed area outside of your home that's generally yours. It's usually just like a common area or space. Mobility is not a factor. The fact that you can move a mobile home doesn't really come into effect anyway in terms of protections under the Mobile Home Park Act, because they usually don't move. So how do you essentially remove or evict someone from a mobile home park? So a mobile home park owner may evict or not renew a lease only for one of the following reasons: non-payment of rent, non-payment of lot rent, because the home is usually owned by the person living there; a second or subsequent violation of community rules within a 6-month period. So when you think of a mobile home park, it's usually multiple people living in a shared community space, and there are rules about like having utility services, how you should maintain your outdoor properties. So if you violate those, or use common spaces, if you violate those 2 times in a 6-month period, then a landlord or a mobile home park owner in this instance can seek to have you removed from the park by going through the court process, change in the use of the community or part of the community. So let's say if a mobile home park owner has 100 acres and he sells 50, and 50 is turned into a farm or something, and the part that you live on is now a farm, then it's no longer a mobile home park, and they can evict you or have you moved from the area on that basis. But they can't just say, we're raising the rent and then we're going to evict you. You have the right to stay there at that point, just based on an increased rent. Termination of the community itself. So if the owner, let's say, gives up the community or shuts everything down and says, I'm no longer managing this community, and the community is hereby terminated, then you can be asked to leave. If the new owner comes in and is deciding to use the new space for a new purpose, they can do that. The one thing that cannot be a grounds for termination or removal from a mobile home park is end of lease term, because essentially the lease doesn't matter beyond, let's say, your first year or two. If once the home is placed there and you agree and continue to live by community standards and rules, and you want to live there, you can continue to live there. You just have to pay rent. If you are there, let's say 5 years after your lease expired and you're not paying rent, then you can be removed from non-payment of rent. But it's not like a rental home where the landlord can say, you have had loud parties all summer and I don't want you there anymore. Like, termination of a term is not a thing in this context. So here's a quick hypo. It should really just reinforce what we talked about. A mobile home owner cannot be removed from a mobile home park if they are paying their lot rent when it's due, complying with the rules of the mobile home park, and desire to continue living in that community. So that's a quick true or false hypo or poll that you can take as soon as it's up on your screen, and we can talk about that really quickly. I'm sorry, I'm gonna go back so you can see the actual hypo. So it's true or false. If anyone has any questions or any unique familiarities with mobile home parks and work in that area, we can take any questions now, or we can talk about something that may have been missed previously.
Yeah, so we don't have any mobile home specific questions at this time, but we do, again, have a lot more questions around just general, like when when should the security deposit be released? Can the security deposit maybe be used to cover 1 month's worth of rent, that sort of thing?
Okay. I think for the security deposit covering 1 month's rent question, it's a question of, do you have first, last, and security when a tenant moves in? And if you are going to seek to apply it to unpaid rent, then what you should actually do is invoice your tenant at the end of that 30-day period or within that 30-day window and says, yes, you've moved out. This is what you actually owe me. This much for rent, this much for repairs or something beyond reasonable wear and tear. And that's how you get to withhold or hold on to the security deposit. You can't just, unless there's an agreement to do so. And if there is, then it should be in writing. You can't just say, I'm not returning your security deposit, because then they can file affirmatively in small claims court and request their security deposit be returned. And I think there's like treble damages that gets applied if the court finds that you have wrongfully withheld a security deposit and have not followed that process. So if there's an agreement that you're keeping the security deposit for unpaid rent, make sure you confirm that in writing once the tenant has moved out. So technically, interest is owed on a security deposit. I don't think I've ever seen interest really returned, except in like 1 or 2 rare instances where someone has been in a property for like 10 or so years. Interest rates right now are just so low that most of these funds aren't really an interest-bearing account. So what you put there is usually the same that is there, plus or minus $1 or $2 when a tenant moves out in a year or 2. But if it's like a long-term tenant, the landlord is required to hold tenant security deposits in special accounts that are separate from their day-to-day accounts. So if you've got, let's say, 10 tenants, then you have to have, it's not really an escrow account, but it's a different type of business account where you just put security deposits and security deposits only. You're not allowed to commingle your security deposit funds with other funds, because you're not supposed to use it for any other purpose than to hold as a security. So hopefully that poll has kind of, so that is 100% true. You cannot be removed from a mobile home park. If you want to keep living there, you're paying your lot rent and you're abiding by the community rules, because termination of term is not an option in a mobile home park community. You can stay for as long as the community exists and you want to pay and live there. So we've got another quick hypo on mobile home communities. This one is a little more involved. It gets to really the same issues. So Alice and Carol have been living in a mobile home with their grandmother for the last 3 years. The grandmother has lived in the same unit for the last 15 years. When the grandmother moved in, the lease was a 5-year term. The grandmother dies the following spring. Alice inherits the mobile home because you can actually hand them down. It's a property that you own. It's of course movable, but it's still considered property. 3 months later, the owner of the mobile home park community shows up, claims that the grandmother's lease is over and they need to move out. We actually don't need to launch a poll for this one, because I think it should be pretty clear that just based on what we just said, if they want to stay and pay and the community still exists, then they get to stay. I don't think it was launched as a poll. It was just a hypo that further clarifies what we just previously talked about. So here are just some unique issues that come up in the mobile home park circumstances. Some unique vulnerabilities that people have to think about as they move into these areas, or that they may face at some point, is that your home is on land owned by another person. And like, unlike a condo association where you have the right to like go and speak and like vote on things, the landlord has the ability to control whatever happens on the property. Usually you have issues where like the landlord's not paying water bills and then your water gets cut off, and then you have to come together as a community and kind of figure out that issues. I know there are like legal services agencies such as the Community Justice Project does a lot of work in that space. So that's something that if it comes up with someone who you're dealing with, you can think about. A mobile home is technically considered personal property and not real estate, because you own the home and the home is movable and not the land of the home that it's on. You may see unregulated rental increases. There's really no way to stop a lot owner from increasing the rent for whatever reason. So if your community changes hands, they can say, okay, I'm the new owner. Your rent is now going to be $100 more a month. I mean, it doesn't usually happen, but these are things that can come up. And of course, if there is a rule that you consider unfair, like a community rule that's set up, it's kind of hard to challenge that without risking an eviction. Now, you can, of course, if you're a community member, like come together as a community and try to form some sort of like working group and discuss issues with your landlord, but you don't really have legal stand-in outside of your individual cases to do anything about rules that are set up. And of course, forced location or like sale of a property that causes you to have to move your home, and like your property value might change and you might actually lose the home because these things they're not built to be moved very often. So when you move them, some of them fall apart. Depending on where you are in Pennsylvania, I've seen like them on the backs of like tractors moving from town to town when someone is moving from a community. So those are just some unique things that really come up in the mobile home park space that can complicate someone's living situation. So I think we've covered a lot, hopefully in a way that people can understand. So now we're just generally going to take questions. And I know we have been covering some throughout. So if there's no questions that we can address, now is the time to do so.
Okay, so there are two ways we can do that because we most certainly have a long list. We can start with some mobile home questions and work our way back to the beginning, or we can start with questions from the beginning. Which do you prefer?
So let's start with the mobile home questions and then work our way back, because I think those are a little easier. Well, I hope they're a little easier for me to answer.
Yeah, so I think, when a mobile home tenant does get evicted, how much time do they have to move their home and how much time do they have to physically move their home?
So I'm not exactly sure on what the time period is that they have to move their home. I think it'll work. There will be a specific court order that says you have a certain amount of time to actually move your home. And I think it might vary depending on facts and circumstances because of the nature of the actual mobile home. So let's say the community's closed, there'll be notice that's given that says this is the last day the community is going to be open and you should move and relocate your home. That should be what happens logically. If the original landlord sells the property and like the new owner doesn't want to use it as a mobile home park, then they can essentially close down the community. If they want to set up new community rules, they can also do that. The land passes from owner to owner, but it's not essentially a covenant that prevents them from, there are no restrictive covenants on the property that prevent them from changing the rules or how things operate in a community. You're basically at the mercy of someone else.
Okay, is there any guidance, like as a landlord in a mobile home community, any guidance about how much they can increase rent?
So there's no guidance that I'm aware of. I would say 10% is always a good number to use in terms of you're looking for an increased rent. I think with mobile home park communities, rent usually increases as expenses increase, generally speaking, or if someone is trying to recoup more money. So if you've got a certain like cost per head or per mobile home that you're incurring and that cost is increasing, you can increase it as a basis of that. Now, I don't know, or I've never heard of, this is not my general area of practice, but I've never actually heard of someone successfully challenging a rent increase. It's usually if the rent increase is above what you can afford to pay, then you decide to move or relocate your home, because you can't go to the court and say my landlord or the landowner has increased the rent and the rent is now too much for me. You have to tell them that they can't increase the rent. The law just doesn't work that way with real property. And it's kind of the same in a landlord-tenant context. Like if my rent goes up by $200, I can't tell the court the rent increases too much and therefore you have to cancel it out. There's just no way to do that in a real life circumstance. But I would say increase it as your expenses increase, or if there's some other metric that you want to use, inflation or something else, you look at what other lots are rented for, because at the end of the day, it's a business. So if the other lots are at a similar price point, then maybe you don't want to be the most expensive lot in the neighborhood unless there's some additional benefit for that.
All right, I'm going to ask one more mobile home question, and then we'll move back to sort of traditional rental. So if somebody is evicted from their mobile home, they're not able to actually physically move the home out of the property, and they just kind of abandon the property. What happens to the title of the mobile home?
So at that point, the mobile home, if it's abandoned, technically speaking, it can be sold by the property owner. There will have to be like post-ins. And I think your local county courts will kind of advise you on how to do this, because you have to serve notice that the mobile home is going to be for sale, as like, it would be essentially a debt collection action where you're saying this person owes me this amount of money and I'm selling the home to cover that. If they've just abandoned the home and left the property abandoned, then I think you have to publicly post that the property has been abandoned and what your intents are. Sometimes after a certain period, you can just essentially destroy the home, because it's personal property, so you can't re-rent it to someone, because that's really not what the business that you're involved in. You can't just re-rent the mobile home when someone moves out unless you have title to it. And if you're taking title by abandonment, then there's a court process that you go through to acquire that title.
Great. Now going back to sort of more typical landlord-tenant relationships in brick and mortar rental properties. If a tenant has moved out, they moved out a couple of weeks early and they never returned the keys, but it's now past the lease term, is it safe for a landlord to just rekey the locks?
So I would say if the tenant moves out by agreement and you know that the tenant is out and it's clear that it's been 30 days and they're not there, I would say reach out to the tenant and confirm that they're in fact out of the property, because you don't want to just change the locks. Like if they're not there for, let's say, 2 weeks, they could have gone somewhere for 2 weeks. Like no one's really going on vacation, but people do go out of town for a certain time period. And what you don't want is to have them show up a week later and say, hey, I just went out of town. You didn't call me. You didn't reach out to me, and I didn't abandon the property. But if their stuff is gone and they're gone to the extent that you can confirm with them that they're no longer there, then you can actually proceed to change the locks. But I wouldn't change the locks without reaching out to the tenant and confirming that they're no longer in the property, and at least using a locksmith or a sheriff to do it. Don't just do it yourself, because you can run into problems, especially when you show up, their property is still there. Like that's a sign that they may still be living in the property, even if they're not physically present in the property.
Okay, thank you. And can you just review again, sort of, what needs to be done for a landlord to end a month-to-month lease?
So let me see if I can actually, that's way back in the slides. So if you are a landlord and you are renting a home subject to I'm gonna try and not confuse screens. If you're renting a home and it's a month-to-month lease and it's not a written lease, if it's a written lease, you can essentially negotiate whatever terms you would like to see in your lease in terms of whether or not you have to provide notice to the tenant, or whether or not they have 10 days to vacate or 30 days, whatever's required. But if you are a landlord and you're ending a month-to-month lease and it's a written lease, then you have to give 15 days notice, and then you file the eviction complaint in a courthouse of your choosing, whatever the county or MDJ office is that's closest to you that covers where the property is. So you file the complaint and then you serve the complaint on your tenants. Hopefully at some point the case gets listed, and then you go through the court process and the court determines whether or not you actually have a grounds to evict. And if it's just termination of term, then you show the court it's a month-to-month lease. I provided sufficient notice, which is generally 15 days. If no notice is required, then you say, I notified the tenant that I was not renewing their lease, because you can't just not tell them anything, unfortunately. And end a month-to-month lease, you have to say, hey, I know notice is not required, but I'm not renewing your lease. Come next month. Usually that is done at the time that rent is paid, just to make people's lives easier, because that's usually the point at which landlords and tenants actually interact in some way, shape, or form. That's usually the safest way to do it. And then you have given them notice at that point, and they can move at the end of the month. But if they're not moving and you go through the court process, then you have to make sure you give them at a minimum 15 days if there's no written lease. If it's just an oral agreement, then you give them 15 days notice, and then you file the complaint, serve the complaint on them, and then you go through the court process. And when applicable, because we are in a COVID period with a CDC moratorium, which technically you might get a copy of that from your tenant with a declaration form saying, hey, I'm covered by the pandemic and I have lost work, lost income, and I would like to hopefully stay and not be impacted by the pandemic. Of course, there are other resources that we'll talk about next week. If there are other issues that are leading you to terminate your lease, let's say like rental assistance or other issues that you and the tenant could probably work through, maybe through mediation. I know that the Housing Alliance is piloting some projects around the state, so there might be the ability for you to come together with your tenant and talk through issues and salvage the relationship. But generally speaking, it's notice, then you file and serve the complaint, and then you go before a judge. And until the judge orders an eviction, the tenant can only leave voluntarily. You can't force them out or change the locks, because that's considered an illegal lockout at that point.
Okay. And for those who have gone through the eviction process and there is a pay and stay order, how many days does the tenant have to pay the judgment?
So I know that some counties have the two-step order process where there's an order of possession and then there's an alias writ process, and some counties just have the order of possession and then there's a lockout. So whatever the time frame is between the court order will say you have 10 days to move out, or 15 if it's more than 10 days for the lockout to happen. It has to be done before the lockout happens. If the lockout has already happened and the landlord has changed the locks, essentially the lease has been ended by the court and the tenant has been removed by the court. Now, if the landlord wants to let them back in by agreement, that's a different conversation, but the lease is actually ended. So up until the lockout happens through the sheriff's office or the county person who's doing that lockout, then the tenant can theoretically pay and stay. But once that happens, then you lose the right to pay and stay.
Okay, and it should be documented on any court documents what that window of time is.
Yes, the court will let you know. And technically, the papers that you get from court to initiate or to the post. So if you think about it, you have a 10-day appeal window for a judgment of possession. So if the court has ordered possession, you have to file an appeal within that 10-day window to prevent the lockout from going forward. So generally speaking, as a safety mechanism, within that 10-day period, if you come up with the money that's owed, then you can essentially pay. But if the lockout actually happens and within the court's prescribed time frame, then you can't then turn around and say, I want to pay and stay. It's, I want to live in this property via a new agreement if you so allow me to. Because if the sheriff removes your property from the home, then it's no longer your home.
Okay. Now going into sort of the intersection of habitability and eviction. So are landlords permitted to temporarily evict a tenant in order to make repairs?
So the phrasing of that question is really interesting, because I would say landlords are required to temporarily relocate a tenant if there's a repair that requires the tenant to not be there. Let's say like you own a 5 or more unit complex and something has happened upstairs that damaged the apartment downstairs and you need to work on it for like a week or a month. Then you relocate the tenant for a month or a week, or you agree that the tenant can use the month's rent and go somewhere else for that time period. You wouldn't want to evict a tenant temporarily to make a repair. It should be a mutual agreement that there's a condition that has happened in your unit that's caused it to be uninhabitable, and we're going to relocate you or allow you to relocate until that happens, not an eviction to achieve that end. So just in terms of like framing of the way we think about it, it should be like relocation and not eviction for temporary repair. Because an eviction is like you go through the court process and like the court says, you can't be here anymore for whatever reason, or you can stay for whatever reason. But if it's if the landlord recognizes that there's an issue that needs to be remedied that requires the tenant not to be there, then that should be communicated to the tenant and there should be some agreement about how that is accomplished. Now, you can't tell the tenant, you still have to pay me a full month's rent, but you can't live here for a month because I need to tear out everything that's in the apartment and replace it. That's unreasonable. But if you're saying, I understand that I need to like tear out these walls and do new sheetrock and new insulation, and it might take a week to 3 weeks, so you can take this month's rent and go stay in a hotel or motel until this is done. That's an agreement to repair and like let the tenant relocate temporarily, but you wouldn't want to do that through an eviction proceeding.
So you mentioned in your answer about, giving back the rent for the month or putting somebody up in the hotel. So is it kind of a reasonable assumption that if a relocation needs to happen because of a repair, that there is some financial responsibility on the landlord to facilitate that?
So generally speaking, if a repair is of such an extent like that the tenant cannot live in the property or the property is uninhabitable and everyone can agree to that, then you're not entitled to rent because the tenant's obligation to pay rent is conditioned on them having a place that they can live in. So that's kind of a common understanding. Now, usually some people are very good about resolving that issue without the court system. Sometimes it has to end up in court, and then the court will like have to issue an order that says you're not entitled to rent for this month because there was a hole in the ceiling that was maybe 3 feet wide, and like everything kept coming in. Like I've heard of that actually happening in people's houses, or like someone has lived without heat for 2 months. Now, no heat in the winter, not in the summer, but no heat in the winter is considered an uninhabitable home. It's not a home that you can safely stay in and not freeze to death in some parts of the state. So that is something that a court will readily award a tenant a rent credit for. So in terms of if I were a landlord and that was the type of issue that I was facing with a tenant, I would reasonably, proactively try to mitigate the cost or time period that's associated with that and not try to force a tenant to pay me rent for a time period when their property is uninhabitable and they have to incur the expense of living somewhere else. It may not happen that way, and it may be up to a judge to make that final decision, but if your property is uninhabitable, you're not legally entitled to rent. So whether you do that proactively by agreement or retroactively by taking this before a judge and the judge making that determination, technically that's the standard that's applied.
Okay, now the next one has to do with, again, habitability. And, if a landlord really refuses to make any repairs for habitability, is there any mechanisms for public takeover of the property for repeated violations, whether it's a single family unit or even a multifamily unit?
So that varies by county to county. I would say if you are in a city that has a home rule charter, which is a really complicated thing, but if there's like city government and the city's making its own rules, there might be licensing requirements and other things that can get pulled. So if your landlord's not making repairs and the property's uninhabitable, the county might come out and inspect the property and pull the landlord's like license if a license is required to rent the property. But if there's no requirement that a license or something is required to rent a property, or let's say that there's a group that comes out and inspects homes on a regular basis to make sure that they're habitable, then public takeover is not something that will happen very easily unless the landlord has abandoned the property, and then the property might likely fall to the city, and the city, if there's like it's really complicated, and I don't know that it helps to say that public takeover is available because the property might be sold at like a foreclosure sale or something else might happen, and there may be a new owner that comes in. But if a landlord exists and is just, let's say, neglecting the property, then I think they will start taking notice when the tenant begins withholding rent for whatever these repair issues are. And once you've notified them correctly and you're withholding rent, then you have strong grounds to stand on if you do end up in an eviction proceeding in court, because then the court will balance what the landlord's alleging versus your withholding and documented proof of the repairs that have not been done. But just saying that there's a public takeover is not a likely thing that will happen with private property. I haven't seen it yet, but it could happen. It depends. I would say you're more likely to get a property condemned or a rental license pulled from a landlord than you are to get a public takeover of a property.
Okay. Now, if landlords sell the property and then new landlords decide that they're not interested in renting out the property anymore, how much notice should be given to a tenant, especially if it's in mid-lease?
So generally speaking, a landlord or new landlord or property owner takes the property subject to the original lease terms, because if you're buying a property with a tenant in there, then the lease is also essentially passed down, or I guess you call it assigned to the new landlord. So if there's a 30-day notice requirement, then it's 30 days. If it's 60 days, then it's 60 days. Some leases may say that a agreement may a lease can terminate by agreement of the parties under specific circumstances. There might be a paragraph that covers sale of the property, but if the property is being sold and notice is required, that's the notice that has to be given for the property to be essentially, for the tenant to be forced out of the property. Usually, I would say that if there's like any sort of ordinance that places additional requirements or restrictions on just like removal of tenants from the property, particularly for short-term leases, that might come into play. But generally speaking, you just have to give the notice that's required in the lease. Some leases might say 60 days notice to terminate. If it's at the middle of a, let's say, say you're 6 months into a 1-year lease and the property's been sold, then you have to give essentially that 30-day notice that says the property is being sold or has been sold to new owners, and the new owners would not like to renew your lease. But technically, a new owner can take subject to someone being in the property unless they are buying it for personal use, and then that should be like made known to the tenant at the time that you put the property on the market and start the walkthroughs. You should say, I'm selling this property. Someone may be interested in buying it to live in it themselves. So you should proactively start looking for a place to go. But you, the old landlord, can't evict them just because you are selling the property. But if the new landlord wants them out of the property, then they have to give adequate notice that they're terminating the lease based on whatever provisions are provided for in the lease.
Okay. And then, is there ever a circumstance where a landlord can terminate a lease or change the terms of a lease early, other than without like the tenant having done a breach of the lease?
So I would say no. And even if the tenant theoretically breaches a condition of the lease, all of the other conditions still apply. So oftentimes leases say if one paragraph is found to be illegal or contrary to the law, then the rest of the lease is fully enforceable to the extent that it complies with the law. So the thing to know is that if you're in a 1-year lease, at month 6, you can't say I'm increasing your rent. You increase the rent essentially at the end of the lease term when you send a notice that says, here are the renewal conditions that apply to the lease. And some leases might say, this lease will renew by default with the prior rules unless a party gives 60 days notice of a change. So like the tenant can give 60 days notice of their intent to non-renew. The landlord can give 60 days notice of a proposed rent increase. If there's no lease, then you can give 30 days notice of a rent increase, and that could go through. But if your lease says you're here for 1 year and your rent is $950 for the full duration, and you've paid your securities on that basis, and you're in for a year, you're locked in for a year on that agreement.
Okay. Now, going back to, I think, the first hypothetical where we had a cohabitation situation that did not fall under a traditional landlord-tenant relationship, and somebody still needed to remove that person from the property, How is that different than an eviction, or what would that process look like?
So that process would be an ejectment where you'd file a complaint in essentially the court of common pleas seeking to eject someone who's living in your property, not subject to a landlord-tenant relationship, because a landlord-tenant relationship assumes that there's that exchange of money in terms of exclusive possession. But if you've just got someone who like moved in and is just living there, you can't just kick them out because they refuse to leave. Like there's a separate court process to do that. So you'll file a complaint in ejectment. I would suggest that you consult an attorney to make sure that you are complying with whatever your local county rules are around that issue for an ejectment of a household member who you want to be removed for whatever myriad of reasons. I don't really cover ejectments because it's not a typical thing that happens and it kind of falls outside of the landlord-tenant space. But it would be an ejectment complaint that's filed, and it's a different forum. So you won't file it in an MDJ, you'll file it at the court of common pleas, usually in your county seat or wherever your county court is located. And they'll hear that complaint and then make a determination as to whether or not you can remove that person. And there's the ability for that person to file an injunction and stay a removal. So it's a different court process because there's no set terms or condition that govern that relationship. It's more of like at the mercy of the court, how much time and what the processes are to remove someone.
All right, well, that brings us to 1:29 on my clock. So I think that should be our last question. I want to thank you for this amazing presentation. I know that we didn't get to all of the questions that were asked, anything that was related to VAWA or the CDC moratorium or anything like that, we will be addressing in next week's continuation of today's conversation. So again, I want to thank Kadeem for the amazing presentation and information. Everybody who joined us for today's presentation and the really thoughtful questions that you posed to us, and we will be seeing you in a week. Thank you.
Thanks, everyone. I hope it was helpful.